what are the ramifications? What are the consequences for this failure? The consequences of this failure mean as follows. The failure to pass the bill has diminished the hopes of women who have been yearning for more women representation through a mechanism built in our electoral system. Our women had so much hope, anchored on Bill number 10, that they would participate effectively in our governance system and take up their position on decision-making positions. Instead of being active participants, women will remain campaign dancers for those MPs who failed to give them the right to be represented in Parliament. Those UPND members of Parliament who have denied our women, it simply means that our women will continue not taking their right position in the decision-making processes of our country. The failure to pass Bill number 10 will mean that our youths, our young leaders, persons living with disabilities, who should, through an electoral system, have a system which allows them to participate in lawmaking processes, will remain reduced to being militias or chola boys of party leaders who are only needed to help those leaders who are sent to power. All those young leaders who are wishing to have safe seats in the 2021 electoral process, that hope has been diminished. All this thanks to UPND. Our persons with disabilities who saw a window of opportunity in Bill number 10, that for the first time since 1964, when we got our independence, persons with disabilities can be represented in the governance of our country, that hope has been diminished, vanished, because of the egoistic interests of UPND members of Parliament. The failure to pass Bill number 10 will mean that government will have no need to proceed with consideration of repealing the 1955 Public Order Act, which many political players have complained about, including the very people who failed to pass and clean up this very important bill. I think we are all aware that there has been a lot of talk around the Public Order Act. And the National Dialogue Forum did the best to ensure that the Public Order Act is repealed as well as replaced. The failure of Bill number 10 signals that the Public Order Act of 1955 is going to be with us and will not be repealed and amended anytime soon. Both the Public Order Bill of 2019 and the Electoral Process Amendment Bill of 2019, which were deferred by government at the insistence of UPA, the nation and political players must prepare to play the same old rules of the Public Order Act and the electoral rules which they have complained about. All this thanks to UPND. Even when there is clear violence in an election, such as the one we noticed in Sesheke, Kaoma, Mtendere, the courts will never have an opportunity to nullify an election, as the current electoral law makes it almost impossible to nullify an election. This is because the Electoral Process Act of 2016 may not be amended as a consequence of failure to amend Bill number 10 of the Constitution of Zambia. All this thanks to the UPND members of parliament. The failure to pass Bill number 10 means that those who will lose the 2021 elections will have to petition the Constitutional Court, and their matters should be heard within 14 days. As you may be aware, 14 days was a cantankerous issue in 2016. Some opposition leader was running from one courtroom to another like a little boy because of the 14 days. What Bill number 10 sought to do was to increase the number of days for the petition from 14 days to 30 calendar days. Now, thanks to the United Party for National Development and its leader, in 2021, the petition will have to be heard again in 14 days. But let's remind ourselves that after the 2016 elections, our judges in this country had suggested and proposed that the petition should be increased from 14 days to 45 days. The NDF settled for 30 calendar days. But thanks to UPND and its leader, they have told Zambians we'll go for 14 days. These are the repercussions in waiting. All thanks to the UPND MPs who made the decision not to participate. They made the decision to abscond. They made the decision to sign for their allowances. They made a decision to sign for their allowances at the parliamentary committee where they sat for 26 days. They made a decision to get taxpayers' money, and then at the end of the day, when they were needed to debate in parliament, they went to drink beer and get drunk. The failure of Bill number 10 has put the delimitation process in jeopardy, as no delimitation of constituencies can happen without amending the numerical numbers entrenched in the Constitution. As you may be aware, our people around the country were looking forward to their constituencies being delimited. The people of Matero, the people of Munali, the people of Mandevu wanted their constituencies delimited. But because of the failure of Bill number 10, thanks to UPND members of parliament and its leader, these constituencies will not be delimited. The people of Chilubi, Mwinilunga, Kasempa, Mfumbwe were wishing that their constituencies be delimited. Thanks to UPND and its egoistic interests and its egoistic leader, these constituencies will not be delimited. The failure of Bill number 10 means that chiefs who have been looking forward to state protection and recognition have lost out. This means that government continues to have nothing to do with recognition of new chiefs or succession wrangles in chiefdoms. So the wrangles and succession disputes that we have experienced across the country in various chiefdoms are going to continue. All that is thanks to UPND and its egoistic leader. Equally, distinguished ladies and gentlemen, the Christians who had wished that the Christian nation clause be entrenched in our constitution have also lost out. Because by not having the Christian nation entrenched in the constitution, our people will not actually see a properly entrenched Christian nation declaration. The failure of the constitution will mean that members of parliament from both sides, either from the governing party as well as from the opposition, will not continue not being members of the councils. As you may be aware, this has been a far cry by our members of parliament, including UPND members of parliament, that they wanted to be in the councils so that they can deliver development to our people. But thanks to UPND, the failure of the bill means that our members of parliament will not be part and parcel of councils as we go forward. The other element as we talk about the councils is to remind ourselves once again that thanks to the UPND, what Bill number 10 seeked to do was to reduce by-elections at council level. As you may be aware, we have been having by-election after another, one election after another, on councillors, as well as on council chairpersons and mayors across the country. Thanks to UPND, this trend shall continue. And the people who are going to suffer the brunt for this trend are the people of Zambia, the Zambian taxpayers' money, who will continue to be paying for these by-elections, which we could have significantly reduced or completely removed through the Constitutional Amendment Bill number 10. Before we proceed to discuss the way forward, we want to clearly state that there was nothing in Bill 10 which was going to advantage one candidate against another in the 2021 elections. There was nothing in Bill 10 which was going to advantage any candidate above any other candidate. It must also be understood that Bill number 10, distinguished ladies and gentlemen, was not about the eligibility of President Edgar Lungu. No, it wasn't. The questions surrounding the eligibility of President Edgar Lungu were already litigated and decided by the Constitutional Court of the Republic of Zambia. We have been made to believe that no, Bill number 10 was seeking a way of allowing President Edgar Lungu to contest the 2021 election. That is a blatant lie, because this matter of the eligibility of the president, in particular President Edgar Lungu, was already settled before the Constitutional Court. And let me be very clear here about the ruling of the Constitutional Court in 2018. They stated that one term of presidents is equal to 5 years. One term of a president is equal to 5 years. 2 terms would therefore constitute about 10 years. President Edgar Lungu only became president of this country in 2015. And in 2021, he would have served for only 6 years. When he was first elected in 2015, he served between 2015 and 2016. He was in office for less than 2 years. In actual sense, he was in office for only 1 year, 6 months. Can 1 year, 6 months be equivalent to 5 years? The Constitutional Court said that period between 2015 and 2016, as it was only 1 year, 6 months, did not constitute a term of office. The Constitutional Court was very clear. Now, some people want to make us believe that 1 year, 6 months is equal to a term. And they want to begin debating a matter that was already closed by the Constitutional Court. This matter, as I've indicated, was ably dealt with by the Constitutional Court. We have also noticed that one state council by the name of John Sangwa says he is going to fight against the third term. I don't know what third term is talking about, because insofar as we are concerned, the third term actually exists only in his head. It doesn't exist in reality. The Constitutional Court was very clear, so Kangwa is playing to the political gallery. Article 52 of the Constitution, which allows for candidates to be challenged, we are going to be with it. And what that means is that all the candidates in 2021, whether be at presidential level or at parliamentary level or at any other level, will be maybe challenged. So it is not only about President Galungu who may be challenged. And so Sangwa must understand that if he is preparing any documents to challenge the nomination of President Galungu, he must understand that President Galungu is not going to be the only candidate in the 2021 elections. Other candidates, including the people that are sponsoring him, may also be challenged. And as a Young African Leaders Initiative, we want to be very clear that we see our courts of law being filled with a lot of nomination papers and a lot of petitions ahead of the 2021 elections. And we want to indicate that as those petitions and those nominations are going to take place, we will ably and effectively participate. So we will be there. And those candidates who wish to contest the election, Sangwa should be prepared to actually defend them and ensure that they don't have any skeletons in their wardrobe. Because Article 52 allows that all candidates, it's not only President Galungu who can be challenged. So if he is preparing for challenging President Galungu, let him also prepare the heads of argument and of defense for those who will also be challenged before the court of law. What is the way forward now that Bill 10 has failed? Our position is that we must put any amendments to the Constitution aside for the next 2 or 3 decades. We still have a Constitution, even though it has lacunas which needed cleaning up. The only remaining option to cleaning up the Constitution is to allow our competent Constitutional Court to continue pronouncing themselves on these provisions of the Constitution. Parliament has failed in its law-making process, and the shift must be the judge-made law, where 7 to 11 special Zambians presiding over the Constitutional Court should take up the mantle, so to speak, to amend the Constitution from the bench. On our part, we want to commit ourselves that we shall always approach the courts to help us clean the Constitution through interpretation of its various provisions and removing provisions which are there, as they did in the last case against the former ministers, without necessarily having these amendments to our Constitution go through a parliamentary process. We want to conclude by emphasizing that our duty now is to go out and tell Zambians what has really happened, who has really lost with the failure of Bill number 10, and dismiss the lies which continue to be told that Bill number 10 was about President Edgar Lungu, when in fact Bill number 10 was never about President Edgar Lungu. Those who want to challenge the eligibility of President Edgar Lungu are encouraged to do so. Equally, those who will need to challenge the eligibility of Hakainde Hichilema or Chimba Kambwili, when time comes, they must be encouraged to also challenge the candidature of these characters. And we hope all candidates whose eligibility will be challenged will respect the decision of our Constitutional Court, as it is very competent to handle such challenges. We don't want to be hearing cries and cries. No. We have given now the responsibility to the Constitutional Court to help us clean the Constitution. And because of Article 52, the Constitutional Court will have to interpret Article 52, but also will have to hear the challenges, the petitions on all the candidates who will seek election in the year 2021. For those women, youth, persons of disabilities who did not get their wish of taking up a seat on the decision table, we want to indicate to them that it is now up to you to ensure that those who have stopped your opportunity to participate in the decision making of this country, you hold them accountable, because they'll come back to you in 2021. So we want the young people, the women, the persons with disabilities to always remember who has denied and stopped them from having an opportunity to be on the table of decision making. We also want to conclude by indicating that our chiefs across the country, our paramount chiefs, should also remember who has stopped them from dealing with the wrangles in their chiefdoms. We want to talk to the Christians in this country and remind them that the ones who are responsible for not entrenching the Christian nation clause in our Constitution is UPND, its members of parliament, and its egoistic leader, Hakainde Hichilema. Ultimately, the biggest debate and vote on Bill number 10 goes to the 2021 general elections. Thank you very much.